Hi, my name's Eric Jenkins and I practice workers' compensation law here at the law offices of Christensen Jensen in Salt Lake City. One of the questions I'm asked most frequently about workers' compensation law is about something called the Allen defense, which is a defense that applies to defeat legal causation in workers' compensation cases. Today's webinar is about the Allen defense. We're going to speak briefly about what it is, when it applies, how to apply it, and some of the pitfalls to avoid when you're working with the Allen defense. But before we jump straight to the Allen defense, let's talk briefly about some of the concepts of causation in workers' compensation cases. There are two types of causation that a petitioner has to establish in workers' compensation cases: medical causation and legal causation. Medical causation is the type of causation that you usually think of in regard to workers' compensation cases. The petitioner has to show, through medical evidence, that his medical condition was caused because of an industrial accident. We'll talk about that accident requirement here in just a second. But medical causation is usually pretty simple, especially when a healthy worker trips and injures herself or experiences some other kind of obvious accident. But what if the worker had a pre-existing condition that affected the same area of the body that was injured in the accident? Or what if the worker had a pre-existing condition that made her more likely to be injured or more prone to injury? And what if the worker wasn't injured in an accident at all? What if she throws her back out while she's lifting a small stack of papers at her desk, or picking up a book, or just walking down the hall? These types of activities aren't usually thought of as accidents. They're part of everyday life and usually just part of job duties. Is a workplace injury compensable if it isn't caused by an accident, but by participation in normal daily activities? These situations are where legal causation arises. To meet the legal causation requirement, a claimant with a pre-existing condition must show that the employment contributed something substantial to increase the risk that he already faced in everyday life because of this condition. Which brings us to the Allen defense, which is really just a challenge as to whether the petitioner has met the legal causation requirement. The Allen defense is called the Allen defense because Allen is the name of the case where legal causation was first adopted in Utah, Allen versus Industrial Commission. This case is a great example of the types of situations I was just discussing. The case arose because Mr. Allen was at work performing his normal duties, which included stacking crates of milk. Each crate had 4 to 6 gallons of milk per crate. Mr. Allen began to have back pain while he was working. He didn't report a fall or a dropped crate or any event that started the pain. His back just started hurting while he was working. He went to the doctor and discovered that he had a bulging disc. Mr. Allen never returned to work, and he filed for workers' compensation benefits for his injury. His employer denied the claim and it was litigated. At the hearing, Allen's employer raised two important issues. First, it argued that Mr. Allen was not owed workers' comp benefits because he hadn't been in an accident. The employer said that Mr. Allen was just doing his job, stacking milk. He hadn't fallen, he hadn't tripped, he hadn't dropped something on himself. There was no event that you would call an accident, and therefore he wasn't entitled to workers' comp. Second, the employer pointed out that Mr. Allen had pre-existing back problems. He'd been in several accidents in his youth and with other employers that had injured his back. The employer argued that Mr. Allen's back would not have been a problem if he hadn't been in these prior accidents, and it was not fair for them to have to pay for his medical bills when the injury at work would not have occurred if not for these pre-existing conditions. The Utah Court of Appeals looked at these issues and some conflicting case law on the subject and tried to balance two different viewpoints. First, that an employer should not have to compensate an employee for pre-existing injuries. But second, that an employee should still be able to get work, even if he'd been injured in the past and might be more susceptible to injury than he had been. It also looked at how the word accident should be interpreted in workers' compensation law. Now, in order to balance these issues, the court adopted the legal causation requirement, which we discussed earlier. It has two parts and addresses both the pre-existing condition and the question of whether or not a particular type of employment exertion is considered an accident. The legal causation requirements are what has become known as the Allen test in Utah. This test has two parts. First, did the petitioner have a pre-existing condition that contributed to the injury? And second, did the employee engage in an exertion that exceeded typical non-employment activities? If the petitioner did have a contributory pre-existing condition and the petitioner did not engage in an exertion that exceeded typical non-employment activities, then the Allen defense applies. Now, at this point, you may be wondering what happened to Mr. Allen. Well, I don't have a great answer for you. The court decided that the record on appeal wasn't sufficient to establish whether Mr. Allen's pre-existing condition contributed to his injury, and the case was remanded back for more evidentiary proceedings. Sorry, I know it's not a very satisfying end to the case. But now let's look at the two prongs of the Allen test a little more closely. First, the question of the pre-existing condition. So clearly, to meet this prong, you must have evidence that the petitioner suffered from some kind of pre-existing condition. But the word contributed here is very important. The pre-existing condition must have actually contributed to the employee's current injury. In other words, the pre-existing condition must have caused the injury or made the injury worse than it would have if not for the pre-existing condition, or maybe made the petitioner more susceptible to injury, something like that. It's not enough that the employee simply had a pre-existing condition, even if the condition was at the exact same place as the current injury. For example, if the employee injured his L5-S1 disc at work, it's not enough to simply prove that the employee had undergone an L5-S1 discectomy 2 years prior. The employer must show that the pre-existing condition somehow contributed to this injury. How does the employer do this? With expert medical testimony. The employer must provide medical evidence that the pre-existing condition contributed to the injury. I suggest that the employer's expert actually use the word contributed in the report. I cannot overemphasize this. If you're an employer and you get the medical report back and it doesn't contain the word contributed, you need to go back to the doctor and ask him to specifically address whether the pre-existing condition contributed to the injury. The court will be looking for evidence of contribution, so make that evidence stand out. Even if it seems obvious that a pre-existing condition contributed to an injury, the employer has to have a doctor establish contribution. It is the respondent's burden to establish contribution in these cases. Also, you should know that the pre-existing condition can be asymptomatic. So even if the pre-existing condition had not been problematic for years, if the employer's doctor feels that it contributed to the injury, it can meet the first part of the Allen test. Now let's look at the second part of the test, which has to do with how the employee was. If the injury occurred while the employee was performing an act that exceeded typical non-employment activities, then the injury is compensable. But if the act did not exceed typical employment activities, then it's not compensable. Now remember, part 2 of this test only applies if part 1 of the test has been met. So if there was no pre-existing condition and an employee breaks her arm while she's picking up a ream of paper or some kind of freak accident, that injury is probably compensable. But if there is a pre-existing contributory condition, we look at how the injury occurred and whether the exertion exceeded typical non-employment activities.
Essentially, this part of the rule says that an employer won't be penalized for hiring an employee with a pre-existing condition who is injured while performing normal types of tasks that most people can perform. There must be some greater exertion than everyday tasks in order for the employer to be liable. So how do we judge typical non-employment activities? The court has said that this is an objective standard judged by what typical non-employment activities are generally expected of people in today's society, not what this particular claimant is accustomed to. So it doesn't matter what the employee is used to doing. If the employee is used to eating fire or breaking cinder blocks over his head, it doesn't matter. What matters is what the rest of society is used to doing. So what activities are generally expected of people in today's society? The court has given us some examples. Typical activities include taking full garbage cans to the street, lifting and carrying baggage for travel, changing a flat tire on a car, lifting a small child to chest height, and climbing stairs. The court has said that these are types of activities that a typical person engages in their non-employment life. So the question is whether the employee was injured while engaging in an activity that was more strenuous than these types of activities. Also, typicality is cumulative, which means that an activity that's typical when it's performed once is not necessarily typical when it's performed 30 or 40 times. The court said we must consider the whole burden on the camel and not just the straw that breaks the camel's back. For example, the courts held that while lifting a tub of merchandise weighing between 15 and 40 pounds once or twice could be viewed as a typical non-employment activity, lifting such a tub 30 to 36 times a day for 2.5 months is not a typical non-employment activity. So just because an activity is considered typical when it's performed once, it's not necessarily typical if it's repeated over and over in succession. So, when deciding if the Allen defense applies to a case, you look at two things. First, did the petitioner have a pre-existing condition that contributed to the current injury? If there was a pre-existing condition and it contributed, then you look to the second prong of the Allen test, which is, did the employee's injury occur while she was engaged in an exertion that exceeded typical non-employment activities? Now, if the exertion exceeded typical non-employment activities, then the Allen defense does not apply. But if the exertion did not exceed typical non-employment activities, then the Allen defense applies.
So there it is, the Allen defense. If the Allen defense applies, it defeats a petitioner's legal causation and therefore defeats a petitioner's entire case. Because of that, I found that administrative law judges are very hesitant to apply this defense. They will apply it, but a respondent has to be ready to establish every one of the elements we've discussed today. The respondent will have to establish them very clearly and with very good evidence. I hope that today's webinar has been helpful for you. If you have any more questions about the Allen defense, or any questions about Utah workers' compensation law in general, please give me a call.